This is an instance where we must remind government that Black Lives Matter, that people must be protected, that we are not going back to the cruelties experienced in the past. And as soon as government slips, it is the job of people like the applicant to come forward and bring this to the attention of our courts so that government can be put in order and that our people can be protected.
The balance between human rights and upholding the rule of law was thrust before the Gauteng High Court in Pretoria. This as the Society for the Protection of Our Constitution forged ahead with its bid to preserve the fundamental human rights afforded to all in Chapter 2 of the Constitution. But the government entities opposing this bid told the court that there was no evidence of such a violation.
There is absolutely no evidence by the applicants. What do they have, my lady? They have reports. They have statements. What if indeed what they sought to pursue was a constitutional right? What was so difficult for them to drive and go actually then speak to? It could have been community members, it could have been family members of those who are down there, it could have been the illegal miners that came out, but there was absolutely no steps taken to get the direct facts of the people that are involved. Yet the government, yet there must be that must be taken against the government. My lady, there is absolutely no basis for this application.
Since the interim order was granted over the weekend, operations have been ongoing in the Northwest Province, which presents a stark change from the perceived government stance that triggered the application to begin with. In order to obtain the final interdict, the applicant has to establish a clear legal right. The applicant must show that there will be irreparable harm suffered if the interdict is not granted. The balance of convenience must favor the applicant, and that there is no alternative remedy available to the applicant. Next week. Kani Mapanga, SABC News, Pretoria.